Good afternoon, everyone. As Taylor said, my name is Nora Ezzat Cozzillio. I am an attorney here with the Tully Rinckey firm in their Washington, D.C. office, where I practice both federal and private labor and employment law. I have been doing so for the last 4 years, primarily within the federal sector, but I also represent private employees as well. And I think that it's very helpful for Marylanders to understand kind of what their private rights are. So that's why I'm doing this webinar today. So moving on. What are employment anti-discrimination laws, right? I'm sure you've heard about it in the news. You've seen it, on social media where people are kind of suing their employers for discriminating against them, but you probably don't necessarily know what specifically they entail. Okay, so what the employment anti-discrimination laws cover, what they essentially state at the federal level, which is what a lot of states have adopted, are anti-discrimination laws that prevent an employer with around 15 or more employees from engaging in any sort of discriminatory conduct related to their employment practices. But in order for it to be considered discrimination, that conduct has to be a violation of someone's protected class. And a protected class is a legal term of art, but essentially it's your membership in any one of these areas. So your race, your religion, sexual orientation, color, disability, genetic information, national origin, marital status, etc. This is not an exhaustive list. There are currently 14 protected classes that the federal government represents or recognizes, in relation to employment. So essentially, what these laws cover is if any employer violates your protected class, such as they have an adverse action against you, such as hiring, firing, in relation to your membership in any of these classes, they have violated those anti-discrimination laws. But before we kind of delve more into them, it's important to know how we kind of got here. Okay, so moving on. In 1964, a very, very important piece of legislation was passed, which is called the Civil Rights Act of 1964. Again, probably something you've heard of. It's mostly because it was so precedential in our history as a nation. That was codified on July 2nd, 1964 by President Lyndon B. Johnson. And that was after John F. Kennedy actually placed such an urge on the nation to help figure out how we can guarantee equal treatment of every American. Again, this was at the height of the civil rights movement at that time, and the nation was really trying to figure out how can we protect our Americans? How can we make that more recognized by the federal government? Which is where the Civil Rights Act came into play. Now, the Civil Rights Act, which I don't expect that you have read it entirely because it is a very, very dense piece of legislation, and it includes a lot of different types of titles. Most notably, Title VII. Now, Title VII is what governs employment actions, right? Anti-discrimination employment actions. And what Title VII also did was create the Equal Employment Opportunity Commission. Now, that is a federal agency. Again, you probably have heard of them before. But what they do is they take in complaints or charges of discrimination, either from federal employees or private employees, and they investigate them. And they make a determination, and they handle these through administrative hearings, as well as in private actions. They investigate them, and then they issue their findings to that specific employee so that they can determine how they want to move forward. Okay, so Title VII is very, very important. It is something that we refer to often as employment lawyers because it kind of is our holy grail. It is a very important piece of legislation, and it set foot for a lot of other states, such as Maryland, to create their own sort of piece of legislation. So what resulted from the Civil Rights Act was Title VII, which is, again, what gives you those rights as employees to say, this is not in line with the laws because I'm being discriminated against based off of my race, of my sex, of my gender, and various things. So moving on, this is what the CRA did for employment law, both for the federal level as well as the state level. So the Title VII, like I said, created a federal law that is recognized across the United States that prohibits employment discrimination based off your protected classes. And they set a precedent. What that also did was give employees a private right of action against their employers, which they also didn't have before this, right? prior to Title VII in the Civil Rights Act, there was nothing really for employees to really do. They didn't really have a method for setting, bringing their employers to court, or having any sort of discussions with them about it. Employers really kind of were able to act with impunity against their employees, regardless of their protected classes. This was even prior to a lot of state legislators recognizing at-will agreements, right? And what this also did was it set a precedent for individual states, again, like Maryland, to create their own employment discrimination laws. Now, what's unique is that a lot of states still kind of just follow the federal guidelines, okay, which are great. They have a lot of protections. They recognize a lot of different types of individuals. They recognize a lot of different types of protected classes. They really do provide a lot of protections that otherwise were not available prior to 1964. But there are some states who really wanted to take that to a different level. They wanted to make that a little more specific, and Maryland was one of them. So now we're going to talk about Maryland's Fair Employment Practices Act, which is their own version of Title VII. So moving on, under Maryland's Fair Employment Practices Act, while it mirrors a lot of the same protections of Title VII under the CRA, it adds additional protections as well. So some of these are providing additional protection for pregnant employees. Under the federal guidelines, while the pregnancy of an employee is recognized, it wasn't always recognized as a protected class. That was usually related to their family status once they actually had the child. Whereas under FEPA, as what we call it for short, Fair Employment Practices Act, that recognizes pregnancy as a protected class for an employee. So if an employee is discharged, for instance, for being pregnant, that is considered a violation of FEPA. Another really great protection that was added is permitting independent contractors a right of action against employers. Now, what I mean by that is typically under the law, independent contractors are seen as kind of their own employer, right? They work for themselves essentially because they are not really tied to an employer. They kind of just do the job. They don't really have any kind of oversight on how they complete the work. Therefore, they're really just kind of self-employed. And that's kind of how it is, with taxes too, right? That's why they're considered a 1099 instead of a W-2. And with that, on the federal level, they're kind of seen as not really having an employer, so they can't really be discriminated against by their employer if they don't really have one. Maryland, when they looked at that, they didn't agree. They thought that independent contractors, while they can take on separate tasks and separate jobs for different kinds of companies, they can still be discriminated against or harassed by those employers. Okay, so for purposes of FEPA, independent contractors still will have a right of action against their employers, despite the fact that they are technically perceived as being self-employed under the law. So it's not really a preclusion for them under FEPA in cases where that happens. Okay, another protection that FEPA added was expanding the rights of employees who have been subjected to sexual and non-sexual harassment. And essentially what FEPA did, which was actually part of their amendment that Maryland did in 2018, was they allowed an employer to be held legally responsible if the person responsible for the harassment to that employee was able to make or recommend employment decisions. And what I mean by that is that if it was a supervisor or a mentor or someone higher up in management that was the harasser to the employee, Maryland attaches their liability also to the employer and not necessarily just to that person. Okay, because the way that Maryland sees that is that that individual represents that company, represents that employer, and they are an agent of that company. And if that company fails to address these issues, then they're held liable for that as well. So that's a really great protection. That is something that is not as common, especially in the federal level. They usually see people as individuals. They're liable for their own torts, their own harassment claims. But Maryland took it a step further and added that liability specifically to employers, which is also done as a deterrent to ensure that employers take action when they get these claims of harassment. So that way they can avoid that type of liability on themselves. Another thing that they've done was allow employees to bring a harassment claim against employers with even just one single employee. As you probably saw in our previous slides, most of the federal protections only apply to employers who have 15 or more employees. Maryland has amended that in their Fair Employment Practices Act to permit employees to bring claims against employers with just one employee. So that includes very, very small businesses. They also amended the amount of time that the company has to be in existence in order to bring a harassment claim. It used to be, I believe, a year, and now they only had to be in existence for 20 weeks before an employee can bring a harassment claim. So that is quite the protection that has been added onto that. And then one of the greater protections as well is in relation to the age discrimination claims. The Federal Age Discrimination Act has a minimum age for you to be able to bring age discrimination claims. It's not just if you're over 40, it has to be when you're within a certain range. Maryland doesn't have that. Maryland says that you can be discriminated based on your age at any age. So that is applicable to people, to younger individuals who might be coming into a older work environment, who feel like they are being kind of looked down upon because they're younger, they don't have as much knowledge, they don't have as much experience, that kind of thing. And they don't have to wait until they reach that age in order to bring this claim. So it applies for them as well and adds that extra protection. So as you can see, Maryland kind of takes these federal protections steps, not even just one step, but several steps further in order to provide our Maryland employees the ability to bring these actions against their employers. And moving on, FEPA, as I said before, is constantly being amended. The most recent major change that it underwent was in 2019, where it also included increased civil penalties with respect to equal pay violations. So previously, those penalties were limited in terms of, obviously pecuniary and non-pecuniary, which is provable and more compensatory, right? But they increase these civil penalties to be a deterrent for employers who violate these equal pay acts, right? Equal Pay Act is both on the federal level. Maryland has its own version as well. Maryland seems to kind of always try to mirror the federal protections, but also take it a step further. So in their major amendments that they did in 2019, they increased these civil penalties, again, not only to provide extra protections and, recompense to Maryland employees, but it's also a deterrent for employers who engage in these violations. Another thing that they did was prohibit non-compete agreements for low-wage earners. Non-compete agreements have typically kind of gone out of vogue over the years. It's just courts have found that they're just really difficult to enforce, particularly when it's a smaller radius, and particularly dependent on industries. If some industries are more saturated than others, so limiting an employee from being able to find another job in that same industry is also just kind of goes against the national labor standards. So Maryland has kind of already not recognized those anymore. But particularly for low wage earners, like I said, they typically work in industries that are incredibly saturated. They don't have a lot of options. So making them have to sign a non-compete, which oftentimes is under duress or some sort of coercion, and then trying to enforce that against low wage earners who already have a very low opportunity to find other positions within that same area. Maryland said that's not fair, and it goes against the national labor standards, and it goes against Maryland labor standards. And that is one of the unique amendments that they've added, because not every state has done that. A lot of states have just kind of relied on the common law rulings on these, which is common law stands for kind of court rulings, right? Whereas Maryland actually codified that into their amendments in 2019 into FEPA. So that was a very unique and progressive stance that they took on that. And as I said, they invoked liability on employers if the harasser made or recommended any employment decisions. So that one was a really good one. And they also very, very nicely increased the statute of limitations for filing harassment claims. Previously, it used to be 2 years. which again kind of limited people's ability to kind of file these claims, particularly as they like to sit and think whether they want to proceed with that. So Maryland thought, it was not necessarily fair to only have it from 2 years, which can fly by very, very quickly, to 3 years. So people can bring up those claims, over almost to 3 years to the day that they can bring these claims in, and really bring that employer to justice. Okay, so going on to that, the next great segue is, how do you bring any claims of employment discrimination under FEPA? Okay, there are two options. There are lots of options, but there are two main options. Okay, you may file a charge of discrimination with either the Maryland Commission on Civil Rights or the Equal Employment Opportunity Commission. And I will kind of break these down as we go through them. But what's important to note is that if you want to bring any sort of employment discrimination claims against your employer, you have to select one of these agencies, or you can do both, and I'll describe that in a little bit, in order to submit your charge prior to filing a lawsuit. This is because the regulations, both federal and state, require you to exhaust your administrative remedies. And by that, they don't necessarily just want every employee who's ever had a dispute with their employer to bring a civil suit, because that would just backlog all of the dockets. And it would require the courts to look at jurisdictional requirements. It would have to have them look at the merits. And honestly, that just takes a really, really long time. Not all of them are meritorious claims. Some of them are frivolous. So they want to make sure that there is some sort of judicial economy where the claims that are being brought into court have surpassed these administrative remedies, and have been heard on their merits in a way to determine whether they can bring them into court. So essentially, you just have to file with one of these agencies. And then at the end of the filing, after your charge has been reviewed, they will issue you something that will permit you to submit your complaint into a court in Maryland under FEPA. Okay, so we'll first talk about the Maryland Commission on Civil Rights. Okay, so under the Maryland Commission on Civil Rights, which is in the next slide, it is an independent agency that investigates claims of discrimination and/or harassment in regards to employment, housing, public accommodations, health services, leasing of commercial property, and the state's commercial non-discrimination policy. Okay, so Maryland Commission on Civil Rights doesn't only hear employment issues, they hear discrimination in various facets of the state's inner workings. Okay, so anything that has to do with employment, housing, public accommodation, health services, they hear all kinds of claims. Okay. They also enforce Title 20 of the state government article of the Annotated Code of Maryland, which, like I said, is similar to Title 7 of the Civil Rights Act. Okay. So essentially, the Maryland Commission on Civil Rights is an agency that hears these actions, that hears these different complaints, and processes them to review the merits and to review whether there was any discrimination that took place or any violations of the Fair Employment Practices Act. Okay, now you're probably wondering, what is that process like, right? If they're an agency, what are they going to do with my claim where I couldn't just have filed that in court? Like, how is that helping me? Okay, so in the next slide, we'll go over kind of the filing process with the Maryland Commission on Civil Rights, which we use the abbreviation or the acronym MCCR. Okay, so what you first do, which you'll see on the road under number 1, is they review your preliminary questionnaire. So what you do first when you decide that you're going to file a charge or a complaint with them is you go to MCCR's website and you file a preliminary questionnaire. And that questionnaire has lots of different questions. They will ask, obviously, your contact information, who you are, what employer you worked for, that type of thing. And then they'll ask the specifics. What exactly are the claims? What exactly are the issues that you were having? Who was involved in that? What were the dates of the incident? Were there any other witnesses, observers, that kind of thing, right? And once you submit that, it takes a couple weeks, but essentially someone will review your preliminary questionnaire and they will move on to step 2, which is determining the jurisdiction. Now, as I said, not all of the claims that they receive are meritorious. Some claims happen to be for people who maybe work for an employer out of state, but they work remotely in Maryland, right? So they have to make sure that the claims and the charges that they do receive, they have jurisdiction to hear and to assist with. So that is the second step. They have to review the preliminary questionnaire and then they have to look at to see if they have jurisdiction and can they help. The third step is they make an initial contact with you. So somebody within that office, a specialist, will contact you either phone or via email to schedule an intake interview. And essentially the intake interview is where they just kind of, they talk with you. They ask any clarifying questions that they had from your preliminary questionnaire. They ask any like confirmation details, usually dates, as well as names of supervisors or management officials that were involved, those kinds of things, okay? And if they don't hear from you, they will send something that's called a 10-day letter, which essentially says you have 10 days in order to get in contact with them so that they complete the step. And that's what steps 3A and 3B kind of cover. If you don't get back to them within 10 days, they will discontinue processing your complaint. So it is really important that you make sure that you answer those phone calls or you respond to their emails, because they are very quick with these deadlines. So it is important that if you do file something with them, that you make sure that you're always in constant communication. Okay, so after the initial contact and the interview has been taken, they then will draft the charge, and they call it a charge, right? Because you're charging a employer, you're charging somebody with discrimination, right, or a claim of discrimination. So they'll then draft that based off of both your preliminary questionnaire as well as the intake interview that you completed, and they'll put that together for you, right, in their format. Once that is completed, they will then send that to you for your review and your signature. Make sure that the dates are correct, that the people that were noted in there are correct, that the contact information is accurate. They want to make sure that they have that completely correct, right? So they'll send that to you for signature. Again, if you don't respond back to them within a certain amount of time, they will discontinue processing your complaint or your charge. So it's very, very important that once you receive it, that you can take a look at that, review it as quickly as possible, so that way you can send that back to them with your signature. Okay, once they get that signature back from you, they then send that to the responding party, which is known as the RP, which is your employer. So they will then let the employer know, we are from the Maryland Commission on Civil Rights. We have received this charge of discrimination from your employee, and we are now asking for your position statement on this. Okay, so that's the next step in that. And essentially the position statement is a formal response from the employer. Obviously, now that they have the charge, they can see what the allegations are. So their position statement is essentially a response to those charges, whether they're rebutting it, whether they're clarifying those details, or whether they are admitting to any of them, which usually doesn't happen. That is their opportunity to provide those details. And once the position statement has been received back from the responding party, which is the employer, then that charge is assigned to an investigator with the Maryland Commission on Civil Rights. Okay, so that's kind of how that filing process works. I know it looks a little arduous and overwhelming, but it's actually pretty simple. And MCCR does make it really, really easy to work with them with filing a process. So now that you filed it and it's being sent to an investigator, this is kind of what the case process looks like, right? So now that it's been sent to an investigator will review the case. So they'll review the charge and they will review the position statement from the responding party, aka the employer, and they'll then start gathering evidence, right? So steps 1 through 6 are essentially that investigator going to you asking for clarifying details or any evidence, documents, emails, that sort of thing. They will do the same with the responding party. They will interview any witnesses that you have to support your facts. So they will do the same for the responding party, and they will continue to kind of gather these things, right? You will have an opportunity to provide a statement to them as well if they ask for that. And then they will also be able to provide that to the responding party, right? And you'll be able to see what they have to say about it. So it kind of goes back and forth. This process can be long, because they're talking to a lot of people, they're reviewing a lot of documents, and they want to make sure that they have done everything very thoroughly, so that way everything, there's no stone unturned, right? So that can take several months. Up to a year even, depending on the length of the charge. If there's a lot of different incidents that you cited, if there's a lot of different claims in there, that can make the process a little longer. So, there will be, times when you haven't really heard from the investigator, and that's usually just because they're either working with the other side, or they're still gathering documents, or they're reviewing things. But the process still continues on. So once that has been completed, they do a final case review where, again, they kind of review everything that they have gathered, both from you and the responding party, and they take a look at everything. They gather it together into a really big case file, and then they will eventually issue you their written finding. Now, sometimes they will say, we found issues of discrimination, or we found issues of harassment, retaliation, whichever it is. And when they do that, they will try to reach out to both parties to see how that can be resolved, right? Oftentimes, they say, we don't really have enough to make a determination one way or another. That doesn't necessarily mean that your actions have been found frivolous, or that they're saying that they didn't happen or anything like that. It's usually that they just didn't have enough that was provided to them, either by you or the responding party, or both, and therefore they can't confidently make a determination one way or the other. Now, that doesn't necessarily mean that that's kind of the end for it, right? They can always kind of discuss mediation, which is essentially an opportunity for both parties to kind of come together with a neutral third-party mediator to discuss how to resolve the issues. Or they can, basically close out your case if you would like to, so that way you can move on to the next step, which is filing your lawsuit that you eventually wanted to do, right? Because then you would have exhausted your administrative remedies. So those are a couple different ways that the case could end up, depending on whether they've issued any findings or whether they haven't made a determination, and ultimately what your goals are. Is your goal really to kind of just move through the administrative process so that way you can file your lawsuit? Or do you want to go through the administrative process because you're trying to find a really good resolution with the best means possible? It really kind of depends on a lot of different factors. But that's the overview of the Maryland Commission on Civil Rights process, and kind of how they do that. Now, when you bring your cases to us and you want to discuss kind of like the filing, we do usually recommend the Maryland Commission on Civil Rights first. Just because they usually are a little more quick, because they are a smaller agency than the EEOC. So their process for processing and expediting these claims is a little different than the EEOC and can be quicker. Again, that also depends on how many claims you have, right? But typically MCCR does a very, very good job of going through these claims and kind of going through the investigation very efficiently, and ultimately giving you something to work with, whether that's issuing the finding in your favor, or issuing something that says that you've exhausted your administrative remedies, so now you can file your lawsuit, right? Again, this is very dependent on your goals, so not all the advice is tailored to everybody, right? But MCCR does a very good job of doing this. But like I said, the EEOC is a great option as well. So moving on to chatting about the EEOC, which I'm sure you've heard more about than the Maryland Commission on Civil Rights. They, like I said before, they were enacted under Title VII of the Civil Rights Act of 1964. That's when they were created. And what they do is they enforce federal laws that prohibit employment discrimination against employers with 15 or more employees. Okay, so they are on the federal level. They do enforce FEPA because Maryland is within the union, right? But theirs is specifically towards employers with 15 or more employees. Okay, they do cover claims against private companies, state or local government agencies, obviously federal agencies, employment agencies, and labor unions. So they do have a wide jurisdiction, a little bit wider than MCCR because they cover different federal agencies as well. But they do have that stipulation that it has to be against employers with 15 or more employees. Okay. So what's the filing process like with the EEOC? One, you submit your charge of discrimination to your local office, and you can do this a couple of different ways. One, you can either give them a call and do an intake with them. And essentially you speak to an intake specialist who kind of takes your information and kind of gets like the basics of it, your contact information, who you worked for, what your position was and what happened, right? And then they'll schedule you for an interview. That interview will be with a specialist who will kind of go through the details, again, a little more thoroughly and meticulously. And you will kind of just reiterate everything, right? You'll tell them everything, and then they will draft up that charge for you. You can also do it yourself. There are forms on the EEOC website in which you can download, and you essentially just fill those out yourself, where you kind of, again, put your contact information, which employer you worked for, provide all of those details, right? The specific incident dates and what happened, that kind of thing. Or you can hire an attorney to do that for you. Again, these are it's a very overwhelming process, obviously, which is why we have practitioners who do this full time, like myself. But either way, that is how you can file your charge, okay? After the charge is filed, they will then assign somebody to the case, which will be an investigator. Okay. And what that investigator will do is reach out to you and let you know that they have been assigned to your case and that they will be investigating your charge. Okay. What they might also do is ask any clarifying questions about the charge. Again, that just depends on if if the form was filled out completely, or if they just have any like lingering questions or anything clarifying exactly what happened, like incident dates, names, that kind of thing. But they will then clarify all of that prior to sending it to the responding party, which is the employer, which is similar with how MCCR does that. Okay, so they will send that charge to the employer and let them know that this has been filed against them, and would they like to provide a position statement on it. Most employers say yes. Some employers don't actually provide a position statement and they kind of ignore it. And that's because they're not really under an obligation to respond. It's always in their best interest to, but some employers just don't really have an interest in doing that. But again, once that's been sent over, the responding party has an opportunity to provide their position statement, which either, again, refutes or rebuts anything that was listed in the charge, or clarifies the incidents, or just outright denies them. Okay. Once that position statement has been accepted, the parties will have an opportunity to engage in mediation. And that's similar to MCCR, where they offer that and state, both of you have provided your statements. Do you want to engage in mediation? The difference here is that mediation in the EEOC process is usually offered before there has been any finding, before the investigation has been completed. And the reason they do that is because they want to see whether that is something that they should still follow through on. Again, they're a very big federal agency. So if they can avoid, doing any, doing any kind of have excessive manpower, doing any kind of investigation, and this is something that can really just be settled with a mediator, they're going to try to see that. Okay. So that's the difference between MCCR and EEOC. Again, mediation is 100% optional. You don't have to do that. You don't have to engage in it, as lots of, employees don't want to, mostly just because they feel like it wouldn't result in anything. They've worked for that employer for quite some time, and they usually know the inner workings, or they're just not interested. Maybe the employer has just gone too far and they're like, I have no interest in really going through mediation. I always recommend mediation because I think that it's a really good step for both parties. I think that both parties will have an opportunity to kind of present their positions and present some information supporting their position, as well as you'll finally kind of get a confirmation on what they're relying on for their position, right? It's hard to kind of move forward in a case process if you don't necessarily have all of that information, and mediation provides you that ability to do that. You can ask questions, you can present different scenarios to them in terms of settlement, and to kind of discuss those settlement demands. And that's information that you wouldn't get otherwise. You know, they're not really going to put that in their position statement, right? They're not necessarily going to talk about any kind of settlement typically. Whereas mediation is that opportunity for both parties in a confidential environment where it's not allowed to be disclosed outside of that, to kind of freely discuss their positions, how they want to move forward with it, and what it would take to settle. So mediation is always a really great opportunity. Again, it is optional. You don't have to do it, and neither does the responding party. But I do think it is a really great step in every case, and I always do recommend it, just because, again, I think it's better to move forward with more information than less. So, and mediation allows you to kind of get that additional information. But should you choose to not move forward with mediation, or the responding party not choose to move forward with mediation, then your charge will continue to be investigated. That investigator will continue to interview people, review any documents or any notes or emails that you have presented to them. And then the same thing on the other side with the responding party. You know, they'll continue to kind of gather all of this information, and see, you know, whether any sort of determination can be made, right? Now, similar to MCCR, once that investigation is completed, which again, similar to MCCR, can take a really long time, they will issue their findings, right? They'll have their report of investigation, and then they'll say, we have completed it, and this is what we have found. They don't always say whether there has been a finding of discrimination, right? Again, a lot of that is very dependent on the information that has been provided to them. If a responding party has not been very cooperative, or has not really presented any of the information that they requested, or if we didn't, you know, if you didn't provide everything to them, that's going to be hard for them to be able to make that determination. But what they will do, if they can't make a finding of that, right? If they can't say there has been a finding of harassment, or there has been a finding of discrimination or a hostile work environment, they will issue a notice of right to sue, which is essentially what I like to colloquially call a permission slip, that basically says that you have filed your charge of discrimination with the EEOC, which is an administrative agency. It has been investigated, and you have been issued this notice of right to sue because that investigation is complete, and you have now exhausted your administrative remedies that are required in order to move forward with any sort of lawsuit against your employer. Right. So when you have that, you now have permission essentially to go to court and bring your employer to court for the same claims that you brought before the EEOC. Okay. And a lot of people really want to just get to that point, and understandably so. You know, if you've been dealing with this for a very, very long time and you're just completely exhausted and you really just kind of want to have your day in court, a lot of clients of mine, and a lot of employees really just want to get through that process so that they can get that essential permission slip so that they can bring their employers to court. And that is what will result from an EEOC charge of discrimination. So both MCCR and EEOC kind of have different ways to do those things, but and again, it always depends on your goals, but you will get, you know, reach a result with options that are good for you. Okay. So the next topic, which is better, right? With MCCR versus EEOC. Again, like I said, that's completely dependent upon your goals and your time frame. MCCR, as I said previously, they work a little more efficiently. They're a little more quick with processing these charges. Again, just because they're a smaller agency, so they're not getting in as many charges as the EEOC. So if you want to go in like a more quick time frame, you can absolutely choose MCCR, and that would still fulfill your administrative remedies requirement. Okay. You can also do a dual filing, which essentially means that you can file with the EEOC and then they send a notification to MCCR about this charge. Okay, so and essentially what they have is an agreement between them that permits that dual filing. So you kind of cover your bases on either side. So that way MCCR is aware of that and they can go through their process as well. See, not every client or employee wants to do that. Usually someone picks one or the other, but it is an option. And essentially that kind of just allows you to kind of distribute your eggs into multiple baskets instead of just one, to cover your bases. And that's usually for people who really want to kind of expedite the process. They want to make sure that they've covered their bases, and that, you know, if they're able to kind of get to the finish line more quickly, they want to be able to do that, right? The other goal or something to take into consideration is whether you want to settle. You know, if you ultimately don't really necessarily want to go to court, but you definitely want to receive some sort of remedy, right? You know, and you want to settle and you don't want to spend a lot of time and money and resources on kind of litigating this. You know, which tribunal is better for you, like which agency? And again, that really depends on how quickly you want to go through that. EEOC does mediation before the investigation has completed. MCCR does it after the investigation's been completed, right? You know, maybe you want to do the settlement or discuss settlement after you have all of the facts, right? So maybe MCCR is better for you. Or if you file your charge and you're like, I really just want to get them to the table so that we can have a conversation, you know, and kind of get this resolved as quickly as possible, then maybe going with EEOC is better, right? So there are pluses and minuses to either one. But the best thing is that there are various options available dependent on your objectives. There's not necessarily one way to go about it. There's a couple different ways to go about it. And in order to kind of determine what's best for you, it's usually best to kind of consult with an employment attorney. So that way you can kind of have a little bit more of a tailored response and advice on what is your best route, what is the best way for you to achieve your goals. You know, again, with being cost and time and resources, you know, efficient, and to get you kind of the result that you're looking for. So those are kind of the different routes to go with MCCR and EEOC. But at the end of the day, they operate to make sure that your rights are protected, that you haven't been have your employment rights violated, and they exist to be able to enforce both the federal employment protections as well as Maryland's Fair Employment Practices Act protections. So that is all that I have for you guys today. Does anyone have any questions? Okay, so this question says, you know, what are the chances of winning in court if the employee lost the EEO case? And that you heard that EEO almost always sides with the employer. Great questions. So let's break it down. First, you asked, what are the chances of winning in court if the employee lost the EEO case? So there's essentially, you can't really lose an EEO case. It's usually they just didn't make a finding, right? So they can either make a finding or they don't make a finding, right? So they never strictly say, you know, we didn't find discrimination or we didn't find harassment. They usually just say there's not enough information to make that ruling, right? So with that, you can't really lose the EEO case. And your second question where you say you heard that EEO almost always sides with the employer, that's not always true. You know, like I said, they usually just say, you know, they don't have enough to make a finding, and they'll still issue you your notice of right to sue. And, you know, or they will say they made a finding. And therefore they'll try to induce the parties to engage in any sort of like settlement or mediation discussions. That again, that's usually a little bit more rare. They usually just say we haven't been able to make a finding because we don't have enough to look at. But we're still issuing you this notice of right to sue. Now, in terms of chances of winning in court, again, I'm going to give you an answer that my mom hates, which is it depends, right? And I know that's such a typical attorney answer to give, but it does. It depends on, you know, the facts of your case. It depends on which court you're filing with, right? You know, you do circuit court, which is right above district court. District court in Maryland is more like small claims court. Circuit court, which is the ones in the different counties like PG PG County Circuit Court, Howard County Circuit Court, that kind of thing. Or if you wanted to take it, even to a federal level, right? Where you take the U.S. District Court for the District of Maryland, right? That depends on which court you choose, right? So in terms of those chances, again, it depends on the court, depends on the facts, but they only really look at the EEO case to see that you've really exhausted your administrative remedies, right? And they want to make sure that you have followed those regulations, so that way you have the jurisdiction to bring your claim to that court. Now, the court is a whole other ballgame, right? When you're in litigation, you're not necessarily, dealing with the same kind of like linear line as exhausting your administrative remedies, right? I mean, you file a complaint, right, with the court, you are going to be engaging in discovery, you're going to be doing depositions and stuff. So you're going to be getting a lot more information than you necessarily got, with MCCR or EEOC, right? So it's important at every stage, right, of the litigation to determine how you want to proceed, because you're constantly getting in more and more information. So again, hard to answer that question in terms of, again, I'll give you, it depends, right? But it's always really good to kind of, if you want more of a tailored, answer, it's always really good to kind of consult with an employment attorney to kind of discuss the strengths and weaknesses and kind of the efficacy of moving forward with a lawsuit. Okay, so the second question I got was, does the EEOC provide an administrative hearing in every state for all employees? That is if the investigation found that the employee rights were violated. So with private employment, the EEOC doesn't really do an administrative hearing, right? So they do the investigation, they issue you're either the finding or the notice of right to sue, right? And if they issue you a finding, like I said, they usually will contact both parties and say, we found there was discrimination and we need to figure out how to resolve this, right? If they just issue the notice of right to sue, then that means that you're going to go to a court to kind of do the equivalent of a federal administrative hearing, right? So federal employees who go through the EEOC process will then proceed to an administrative hearing. Private employees will be issued something that's called a notice of right to sue, where they can now take that charge and turn it into a lawsuit to bring their employer to court. So that's kind of how that works. So there's no really administrative hearing, but you just have to bring them to court. So that's kind of how that works. Okay. Do I have any other questions? Okay, well, if that's all, I appreciate you guys joining me today. I hope that I was able to answer your questions. If you'd like to chat more, if you'd like to book a consult with me, I do consults for the firm. So if you would like to, our contact information is up on the screen. You can just call that number and they will send you over to our client relations department, who will get you booked with me. Otherwise, I hope you guys have a great rest of your day, and thank you for joining me.